policy is in fact made by the courts. This, of course, very true in the case of common law countries, where the judges have a lot of freedom or a lot of room for maneuver to determine the conditions under which certain cases are decided. But it's also true in the case of continental law countries, in which judges in the end provide the final interpretation for the provisions contained in the laws or the international treaties. And certainly there are many examples that show the importance of the role that the judges play in making the implementation and interpretation of the TRIPS agreement and the national laws in relation to patents, test data, and access to medicines. I will just mention a few examples. One interesting example is a decision taken by the Supreme Court of Sri Lanka in 2003, in which the Supreme Court of Sri Lanka considered that some provisions in a bill that were proposed by the government was not consistent with the TRIPS agreement flexibilities, and therefore it was not constitutional. So that's a very interesting precedent of the Supreme Court framing the legislation, including in particular the issue of TRIPS flexibilities. Another interesting example relates to the issue of enforcement of intellectual property rights. In many countries, in many developing countries, you will find paradoxically somehow that some disciplines are applied in a very rigorous or rigid manner. For instance, this applies to the cases of provisional injunctions. Provisional injunctions in some developing countries are almost automatically granted, and then the alleged infringer is put out of the market. Interestingly, this is not the case in developed countries, such as, for instance, in the United States or in Canada. This is also a situation in India. And there is a recent research paper by the South Center, is the research paper 119, produced by Professor Sarnoff, where there is a very useful analysis of the way in which judges apply the regulations on preliminary injunctions in different jurisdictions. And it shows that, in fact, in the United States, for instance, it's very difficult to get a provisional injunction in relation to an alleged infringement of a patent. And sometimes this is not the case in developing countries. This shows these situations. And the database that is being launched now will help a lot for judges and decision makers in developing countries to know how in other jurisdictions some decisions are made in this respect. Of course, there are many other cases, the case of Novartis by the Supreme Court in India, that provide a very interesting doctrine about the coverage of the patent and the disclosure of the patent. This related to so-called Marcus claims. And another further example is the number of cases in the United States where the courts have granted compulsory license, not the administration, but the courts themselves. The same applies in jurisprudence in Germany, which has been analyzed, in fact, as part of this database, jurisprudence in Russia and other countries. So in sum, I think this is a very important tool. We are very glad of this cooperation with UNCTAD. This is just one step more in our long-term cooperation. And we hope that this new tool will be of help for all that need to make decisions at the level of legislation, at the level of jurisprudence, in order to ensure that implementation of intellectual property is sensitive to public health needs and in particular access to medicines. Well, thank you very much again. Welcome.
Thank you very much, Professor Correa. And now I pass the floor to Christoph Spennemann, an officer in charge of the Intellectual Property Unit of the Division on Investment and Enterprise of UNCTAD.
Thank you very much, Viviana. Can you hear me?
Yes.
Very good. So good afternoon, everyone, colleagues, friends, dear Carlos. On behalf of the United Nations Conference on Trade and Development, it is my pleasure to welcome you to this launch event of the Caseload Database on intellectual property and public health. I would like to express my sincere gratitude to the South Center for having supported UNCTAD's work in this context. I'm pleased to see this database as a result of continuous and excellent collaboration between UNCTAD and the South Center in the area of intellectual property and health. And Carlos, of course, you mentioned previous work undertaken by UNCTAD in this regard. And let me mention here that you, of course, played a decisive role in getting these publications together. So the collaboration really goes back for quite a while. Now, the current pandemic that we're all facing illustrates the need for equitable access to essential medicines and the need for sufficient production capacity in developing countries. It is true that IP rights are often used as tools to ensure investment in pharmaceutical product development. But at the same time, we can use the IP system to promote access to medicines. This can be done by sharing technology to enable the building of local manufacturing capacity in developing countries. Of particular interest for our meeting today, IP regimes make available flexibilities to boost investment in generic competition. Next to national policymakers, it is the judiciary that plays an essential role in striking a fair balance between the goals of promoting innovation on the one hand and access on the other. By providing a collection of court decisions from various jurisdictions in the area of IP and health, we seek to illustrate how courts have interpreted national laws to strike such balance. We hope that judges and other stakeholders in the developing world may find this database a useful resource. Dear participants, dear friends, it is a real pleasure to see again, after a long time, some of the judges we worked with some years ago. The idea of creating this database actually goes back to the series of capacity building courses for judges that UNCTAD organized between 2012 and 2018 at the regional and at the national levels in Africa, Asia, and Latin America. So what is this database and what is its objective? The database is a collection of case law of court decisions from various jurisdictions on the interpretation of domestic IP laws. The WTO's TRIPS agreement only provides for minimum standards of IP rights and leaves it up to WTO members to implement these minimum standards in domestic laws. But as you know better than anyone else, domestic IP laws cannot possibly provide for an exact definition of every concept of intellectual property law. How do you define the term of invention? What exactly is required for novelty, inventive step, and industrial application? And how are these concepts applied to pharmaceutical technologies? When we delivered our training courses, we realized how difficult it is to talk about these concepts in general. We were often requested to, provide concrete examples of cases and decisions by courts in other countries to illustrate the points we were trying to make. And we noticed that the discussion of a concrete case would guarantee our participants complete attention and focus, even after a long day in our training course, or despite the fatigue after a nice lunch, so to speak, the infamous graveyard shift. So on that basis, we decided to develop a repository of court decisions, an online database that can be consulted by any interested judge at any time, and that can also be referred to and used by a country's judicial training institution or judicial academy. The first element we thought would need to be included in the database are the original court decisions to which we provide direct links. There are, for the time being, some very few exceptions where we were unable to track the original decision. The second important element in the database are summaries of the original court decisions that we ourselves have developed. The objective of these summaries is to provide the reader with a quick understanding of what the decision is about, in case you do not have the time to read the entire original decision. As you know, a case may involve a multitude of different aspects. Our summaries focus on those parts of a decision that are particularly relevant for the interface between IP and health. For instance, a court's analysis of a specific TRIPS flexibility, such as, for example, the regulatory review exception in patent law. Each summary begins with an introductory sentence or paragraph that introduces the subject matter of the case. We then provide the facts of the case and the main legal issues that the court had to decide. Finally, we summarize the points that we find most significant in the decision from a public health perspective and place the subject matter of the case within the broader framework of the TRIPS agreement. We also provide cross-references to other decisions that in our view should be considered in conjunction with the case at hand, either because they take a comparable approach, elaborate on the summarized decision, or because they deviate considerably. Now, the great majority of our cases relate to intellectual property law and pharmaceuticals, of course. Some cases do not have a pharmaceutical background, but they nevertheless spell out important principles that are of direct relevance to pharmaceutical patent law. Let me mention in this context the US Supreme Court's opinion in KSR International and Teleflex, which we have included in our database and which elevated the standard of inventive step or non-obviousness in the United States. The decision concerned automobile technology, but the key considerations apply as well to pharmaceuticals. As my colleague Ermias will demonstrate in a few minutes, the database covers those TRIPS flexibilities that are relevant to public health. If, for instance, you wonder about the patentability of human genes, please check the cases in our database on patentable subject matter, for example, the Myriad case of the United States Supreme Court. The decision of the Indian Supreme Court in the Novartis case sheds some important light on the Indian approach to the notion of invention. How do you construe the claims of a patent on a new medical use? And what can be expected from a generic competitor to avoid patent infringement? These are issues addressed in the part of the database related to patent claims interpretation, for example, by the England and Wales Court of Appeal in the case of Warner-Lambert. If you wonder about the requirements for granting a compulsory license for the production of essential medicines, please consult our summary of the decision by the German Federal Court of Justice in MSD and Shionogi, which Professor Carlos Correa also mentioned before. Or compare the approaches, as also mentioned by Carlos, taken by the Canadian Federal Court and the United States Supreme Court regarding the extent to which injunctions for patent infringements are granted or are not granted to patent holders that do not practice their inventions. Finally, an important part of our database addresses decisions on the interface between intellectual property and related issues. Here you can find more clarity on how the competition authorities in Italy and South Africa have addressed anti-competitive conduct by certain holders of pharmaceutical patents. You can also update yourselves on a decision by the Peruvian Constitutional Court regarding the right to health and the role of TRIPS flexibilities in this context, including the Doha Declaration on the TRIPS Agreement and public health. The database is work in progress. As of today, it contains 81 cases and summaries. It is our intention to continuously fill it with more cases. For the time being, we have a lot of decisions from Anglophone countries. We're happy to discuss the inclusion of decisions from other jurisdictions. As the database is generally in the English language, we would have to find ways to translate decisions in other languages, or at least prepare English summaries of the decisions. Finally, the database is available open access under a Creative Commons license. This means that you are free to reproduce and distribute the work and make adaptations, including translations of the summaries in different languages as may be useful in your specific national contexts. We also encourage you to include elements from the database in any training courses, for instance, at the Judicial Academy. We would ask you to acknowledge our original authorship in the database and provide for links to the UNCTAD and South Center websites. Let me now invite my colleague Ermias to take us through the features of the database. I thank you for your attention, and Ermias, you have the floor, please. Thank you.
Thank you very much, Christophe. And I would also like to thank South Center, Professor Carlos Correa and Viviana Munoz for their excellent cooperation and for assisting us to develop this database. It's been in the making for a long time, but I think it was the cooperation from South Center that made it possible now. I would like to take you to our website where we have the database. I hope I'm sharing the screen now. I hope you can see the web page of UNCTAD on intellectual property unit. You can see that we have the case law, or the link for the case law summary is here. But I also want first to introduce you to the other elements of our website. As Carlos Correa was mentioning, we have several publications on intellectual property. You can see the list of publications here. It includes also the reports for national advisory services and also some other publications on intellectual property in general. Now, let me take you to the database of the case law database. Now, you can access the materials in 3 ways. There are 3 options provided here. The first is the search option. I think sometimes you would like to have information on a specific issue, and you may want just to do some research and find the appropriate cases. Now, one of the issues mentioned during the presentation by Professor Carlos Correa was injunction. Let's see what we can find on injunction on the case law database. So we have 2 cases. One of them from the United States and the other one is from Canada. The case by the United States is a decision by the Supreme Court. That means it has strong weight. It has interpretative value. If you click the summary, then it will take the highlighted title of the case. It will take you to the summary, from which you can have the appropriate the information that you need. Just going back to the results of the search, the first thing you notice is that there is a title of the case, then followed by a brief description. So the first case says, for example, the Canadian Federal Court granted a limited injunction. It continues. So this can help you. The description is supposed to help you to decide whether you want to explore further the case or not. Now there are 2 links provided. One is for the summary in PDF. So when you click it, it will be a new web page with the summary. The other is for the link to the original decision. So most of the time, this link works, but sometimes, especially for cases in some developing countries, the link may change from time to time, so it may not work. So, but most of the time it works. So when you click the link, it will take you to the web page, to the decision itself, or to the web page where you can find the decision. Okay, going back to the first page, to the front page, the second option to use this database is by keywords. So there are some keywords here identified. You can, for example, try inventive steps. This one specific topics that you might be interested at one point. So if you click inventive step, then you find all the cases that cite inventive step. It doesn't mean necessarily that the cases are really focused on the issue, but inventive step is one of the issues that the cases have addressed. So this is another option to access the case law database. Here you find that a decision by the first decision is by United Kingdom Supreme Court, the Activa Group PTC versus the other, the ICOS Corporation. And the second case is from European Patent Office Board of Appeals. The third case is from the States. You can see very diverse decisions are here, summarized here. So also the question of the, I think it was mentioned already, the Indian Supreme Court decision on Novartis versus the Union of India, which also touched upon the issue of inventive step. So this is the second option to access the case law, the case law summaries. Now, there is also another one, which I think is a better way to find cases. This is by categories. So we have three broad categories on the database. You see the first one is pre-grant flexibilities. The second category concerns post-grant flexibilities. The third one addresses all related issues. Now, in the first category, we have other subcategories. The first question is exclusion from patentability. The other one is patent claim interpretation. The third one is patentability criteria. And the fourth one is patentability subject matter inventions. So under each subcategory, there are case summaries made available for use. So if you open exclusion from patentability, for example, you find several cases dealing with methods of treatment, treatment by surgery, so many other issues from different jurisprudences. There could be some overlap. Some cases, I think you can imagine that exclusion from patentability and patentable subject matter, defining patentable subject matter, sometimes are really overlapping. In some jurisprudences, the question of gene patenting could be just a matter of defining invention. In other cases, it could be whether it should be excluded from patentability based on morality or other grounds. So there could be overlaps in some cases, and that is reflected. So if you look at here, we have a case from New Zealand that appears both in this in the patentable subject matter, defining patentable subject matter, and also on the question of what kind of inventions are excluded from protection. The case of Novartis also appeared here, and Mayo collaborators in the United States. These are cases that appear in different categories, but this is very limited, and it's mostly affecting the first categories. Then the second category is post-grant flexibilities. It deals with exceptions to patent rights, then exhaustion and parallel importation, and finally non-voluntary licensing or compulsory licensing. So under exceptions to patent rights, there are several questions like experimental use, regulatory review exceptions, but all of them are presented together. So you find several cases from different jurisprudences under this category. Then for exhaustion and parallel importation, also dealing we have limited cases now, both of them from the United States, but they also deal with both the parallel importation and exhaustion in the context of domestic law. Finally, we have also a subcategory on non-voluntary licensing. I think one of these recent cases from Germany, for example, is here on concerning compulsory license. It is very important, as it was noticed, in developing countries. It seems that courts may not be comfortable in making important decisions, whether it's on injunction or compulsory license, while the experience in developed countries is different. So if you look at this, there's a very detailed summary. This is unique compared to other case summaries. We've done here detailed work so that it provides good context, also describes the points of significance of each of the cases. The significance of the cases. Now, the third category has 5 subcategories. The first one is what we call patent leakage, or we call it here drug marketing approval and patents. The second one concerns enforcement. The third one concerns competition law issues. Then the fourth category concerns pharmaceutical test data. And finally, we have the right to health category, which is, there are rare cases, but we have 2 cases, one mentioned by Christophe from Peru, and there is another case from Kenya, which is already included here. So if we look at the patent abuse and the group of cases on patent abuse and anti-competitive practices, you'll see that actually this is a very diverse, this is a database, this part of the database is very rich. It has cases from different jurisdictions, from European Union. The first 2 are from European Union. The first 3, I believe. Then we have a case from Italy. We have also a case from South Africa and from the United States. Yes, okay, and from the United States. So there are so many cases from different jurisdictions dealing with patent abuse and anti-competitive practices. So again, the way you access the file is, first you could decide whether the jurisdiction, European Union or United States, is more relevant for you or not. Then whether it is a High Court or a Supreme Court decision, probably that's important. Then we have provided a brief description of what the case summary is concerned about. So you can read this brief description and may decide whether it is a case you would like to read further or not. Then, as I said earlier, there are 2 links, one for the case summary itself, and another one for the original source of the main decision itself, which is provided in the website of the countries concerned. I think that's most of it on how to use the website. Maybe I could also try to describe to you if you have further questions, and also maybe, as Christophe mentioned, that if you also want to contribute some cases, you could, the contact is provided here for UNCTAD and South Center. So we will be able to prepare summary of any cases that you may recommend. Or if you have also prepared the summary itself, we could also include them in this database with appropriate attribution and recognition. I think with that, I think I'll follow up maybe based on any questions that we may have.
Thank you very much. Thank you very much, yes. Much appreciated. Viviana, I think you would like to tell us a bit more about South Center's program on access to medicines and training of judges. You have the floor, please.
Thank you, Christophe. And yes, I'm sure that many of you participating are anxious with some questions or comments on the database. So I'll try to be short in my presentation. What I'd like to do is just basically take you through also the capacity building program more generally, which includes, of course, the use of the case law database as an input. So this, as Professor Correa has mentioned, is a project that the South Center has been doing for quite some years now, and more intensively since 2018. So just to mention to some of you that might not be aware, the South Center is an intergovernmental organization and a think tank of developing countries with a large membership across regions. And our particular mission is very much geared to ensure that the international regimes and national policies have enough policy space in order to address development concerns. And in this linkage, then we address the issue of the tensions between intellectual property systems and public health. So as has already been mentioned by Professor Correa and Christophe Spenneman, it is really important to promote a competitive market environment by ensuring that national intellectual property regimes and the international rules can be supportive of public health goals. So one important way to do that is through the use of TRIPS flexibilities, and also recognizing that judges have a key role in this respect. So we have a specific project website that you find here, the link, specifically for this area. And you will find that our website looks as you see here in the screen. We have a number of information, of course, a general description of the projects, as well as specific work on COVID-19 pandemic, which has taken increased relevance, in addition to the relevance of TRIPS flexibilities more broadly for many disease areas. Then you find also here the link to the Caseload Database, a number of services we provide that I'll mention more in detail, publications, and events that have been organized. So just in terms of services, one of the big areas we're providing in this project is national and regional capacity building. And it's geared at different government agencies, in particular trying to promote policy coherence and understanding between different areas, including those ministries of health, ministries of trade, foreign affairs, patent office, as well as the judiciary. So we do have specific programs for capacity building of judges. We also have advisory services that extend to many different areas, and as well as different level of national and regional workshops. So in an events page, you can find different events as you see here. And just to mention some of the events that we've been doing on particular the area of capacity building for judges. We've done some of them with some of you who are joining us here today. For example, Gabriela Talavera from the Supreme Court Justice in Paraguay. And also we've had trainings with Brazilian federal judges. Of course, I also note that Maria Marcia Nunez is here with us today. And we've also had regional level courses, for example, for Latin America. In Argentina, we did it at the end of 2019. And as you see, it's also a nice moment to have nice places, nice locations, in addition to a lot of content to discuss. So unfortunately, in this past year, we have not been able to do face-to-face trainings, but we've continued to do a number of trainings also online. We've now started an online e-learning platform training, so as well we'll be able to extend this work in the virtual format. But we do expect that by next year, we'll be coming back to face-to-face trainings. And what we have in the works, just so you know, we will be doing an Asian level regional training. We had that planned and already ready to go earlier this year in Thailand for Asia region. And many of you perhaps had been invited. Of course, last minute, because of the COVID pandemic, we had to postpone. We will also have an Africa regional level training, a global forum that invites many judges as well, and some of you have participated as well, to interact with other regions, and not only of judges, but other government agencies. And so we expect to have that also by the end of next year. And we also can take up requests for particular national training of judges in these areas. So thank you very much. You also have references then for further details. And with that, I'll come back to the general floor so that we can now open for questions and discussion. Thank you very much.
Thank you very much, Viviana, for this interesting presentation on the Cell Centers program. We are now happy to take any of the questions that you may have on the database or on the respective work programs of our organizations. Feel free to speak up. Thank you.
May I? Hello?
Yes, please.
Marcia from Brazil.
Marcia, please.
So good to see you all. Thank you for inviting us to be here. I would like to congratulate you all from Southampton and UNCTAD for this great initiative. And I would like to know how can we submit our decision, Brazilian decisions, to be in the platform.
Well, thank you very much, Marcia. Much appreciated. Feel free to, well, as I said in my introduction, the database, of course, is in the English language. We would very much welcome if you could, provide us with your cases. Would there be some way of having an English summary? Because we would be happy to include the original decision in Portuguese, I guess. But is there a way of getting a two or three page summary from your side? Unfortunately, none of us is able to speak or understand Portuguese. At least that is true for the UNCTAD team. I'm not sure what the South Center colleagues, I guess they do speak Portuguese, so we have to see. But would there be in general, I mean, this is a question that goes to all of you. If any of you would like to make available a decision, we're happy to include the original version, of course, in your respective languages on the database. But we would need a summary in the English language so that everyone can basically understand what the decision is about. So if you can provide that, I think that is basically what we would ask from you to include the case in the database.
Okay, but are you going to evaluate the relevance of the decision? If it fits your database, do you need a complete translation or only this summary is okay?
No, I think the summary, if you can see what our summaries are like. They're usually a 3 to 4 page summary that explain the facts, the main legal issues, and the points of significance as relates to the interface between IP and public health. And if you do that in an English language document and submit it to us, we're very happy to look at it. And on that basis, of course, we take the decision if we want to include it or not, right? That is as far as I would think. Yeah, this is what we would do. Viviana, any thoughts on this?
Viviana,
Hi,
nice to see you.
No, of course. If we do have a Portuguese speaker on our team, so perhaps there could be some space to help out with part of the summary if it's in Portuguese to translate that to English, if that's necessary, or we could find the translation. But I think the point is the more explained and summarized it can be already, that perhaps will also help in the process, and then we can deal with the translation issue on our side.
Yeah, thanks very much, Viviana. I think in a more general context, we may, we have countries, of course, like Vietnam and other countries where none of us speaks or understands the language. So there we would really rely on an English 3 or 4 page summary from you for us to decide whether to include this decision in the database. That being said, of course, nothing prevents you from making your own translations of our English language summaries in your own languages, and use that for respective training courses in your countries. As I said, this is a Creative Commons copyright license, and you're free to do that as long as you kindly acknowledge the authorship in the original work. So I would really encourage you to send us your decisions that you think are relevant, and yeah, with an English spoken summary, that would be fantastic. Thank you.
Okay. Thank you, Christopher. Thank you, Viviana. As I told you, Christopher, once my training in 2012, I think it was one of the first training for judges, and it was life-changing. I use the materials, all the papers and your publications daily in my work. Thank you very much for everything.
Thank you so much, Marcia. It's really good to know this. It's really the best feedback we can get. I'm really happy about this feedback. Thanks, Marcia. Any other questions or comments on what we discussed? You're very welcome to ask any questions. Including the use of the database that Ermias took us through. Or let me maybe ask our participants, let me ask you a specific question. I think you are all aware of your respective national judicial academies, the training institutions. Do you think they would be interested in using this database? Do you think this could be something that could benefit their work? I think that from our perspective would actually be the best thing to do, because despite the fact that Carlos and Viviana and the team are traveling around the world to provide for the classes, this is something that, it's important to have a sort of training of trainers effect. And if the database can be used in a judicial academy kind of context, I think we would have the greatest impact and the most sustainable effect of our work. So I would really encourage you to think about to what extent you can use this in a judicial training institute. Any comments on this are welcome.
Yeah. Good evening. Can I speak?
Please go ahead.
Yes. Good evening, everyone. Now, first of all, I'd like to extend my sincere thanks to the South Center and UNCTAD for initiating this very important event and preparing a database for the practitioners. I think the database is very useful for the judges and the other professional. So far as the applicability of the database in Nepal is concerned, we have established National Judicial Academy, which have been initiating training program for the judges and other court personnels in collaboration with the World Intellectual Property Organizations and other UN agencies also. That's why this database link would be made available to the National Judicial Academy in Nepal from my side. And I would also like to request with the executive director of the academy about the use and applicability of the database and usefulness of the database in Nepalese context. That's why it would be a very important tools for the capacity development of the judges in our context. Thank you very much for providing this important information. Thank you.
Thank you very much, Tech. Much appreciated. We really appreciate your interest in the database, and please get back to us with any questions you may have. Thank you. Any other views?
May I please?
Please, very welcome.
I'm very sorry, but I can't turn on my video because my bandwidth is low. This is Reina Tan Francisco from the Philippine Judicial Academy of the Supreme Court of the Philippines. And I am a judicial education attorney. And I'd like to thank you for the planned trainings for Asia. And we hope to get included because I see this as a very, very helpful tool for our judges and maybe for some of our justices as well, because the Philippines has not, well, we have an intellectual property office and we do the best we can, but we do have a lot of cases of IP violations in my country. So there's a lot of training that can be done and must be done on the part of the judiciary. So I thank you, and this is a very welcome activity, if ever. Thank you very much.
Thank you very much. Much appreciate your view. Would there be other comments or questions?
Christoph, just to note that there has been a quite overall positive response to your question in the poll section.
That's great. Okay, very good. Thank you for this news. Well, I guess, Amnius, you did an excellent job explaining the database. There are no open questions. Congratulations.
I think the database is very simple to use, so I don't think people have problem in using it.
Right, right. Let me in this context maybe also mention that other stakeholders could also benefit from the database. I mean, this is of course this is case law. This is something that judges can use, but I think any intellectual property lawyer that is interested in the TRIPS flexibilities and in the health context can use this database, because of course also for attorneys, law firms, it is important to understand what the case law around the world is like in this area. So I know that we have a few participants here among us who are not directly judges, but are closely related to courts, but are, let's say, private lawyers. And I think also in your respective contexts, I hope that you would benefit from this database. Please, Marcia.
Hey, Christoph. I work with Marcia. I'm from Brazil. I am one of the judges. The other one is Laura, who is also here. And we are thinking about maybe create a small community of judges and justices so that we can discuss some healthcare problems and the IP problems, just to solve some doubts that we might have while we are deciding cases, and maybe other colleagues had this same problem, and maybe we could start by email or maybe by WhatsApp or something informal like this, because sometimes the problem that we are having here, it's exactly the same that other colleague had just some time ago.
Yeah, thank you very much, Carolyn. This is a very good idea. We're happy to discuss with you what can be done in that regard, and with our colleagues and friends from the South Center. So let us know what you have in mind, and we follow up maybe by email, and we can also organize another chat. And I would think that anyone who is interested in such a group of informal exchange would be very much welcome to do that. I think that would be great. We have made the experience in the past when we did these training courses that a vivid exchange between judges on a platform that is specifically designed for that was actually quite good. We would, after each of these training courses, have a very active exchange between the judges that, of course, still remembered the course and knew each other and got in touch, and that really made a big difference. And then, of course, as you go further and further away from the course, and once the course is more than 6 months ago, it kind of gets a little less active. But yeah, I mean, why don't we discuss these kind of discussion fora? And I think by email would be a good start. Thanks very much.
Thank you.
So, may I have a some comments to the database, Christoph?
Please, Beek, you're very welcome. Thank you.
Yeah. distinguished judges and experts, dear colleagues and friends. I'm the speaker from Vietnam, and it's my pleasure to be invited here to join this launch. And I'm glad to know about the South Center's UNCTAD database on case law, on chief and public health. And I think this database is very useful, not only for judges, but also for all IP practitioners, including the trainer at the judicial academies, and also for lawyer, IP lawyer, attorneys, and schuler. I have been delivering the IP lectures for Academy of Justice for 20 years, and I found this database is very, very useful. But as you might know, in Vietnam, in our countries, there are only a few case, IP case to be dealt with the court. But we think there's maybe some case to be raised at the court in the next futures. But our judge has only limited source of the case in relation to the patent infringement or patents flexibilities in terms of the chip flexibilities. So I think that if we appreciate if this database will be translated in our language, because only a few of judges in Vietnam can speak and read in English, only in Vietnamese. So we appreciate if this document or database is available in Vietnamese, and we appreciate if any training courses are provided either by UNCTAD or the South Center to our judges or IP practitioners in Vietnam. We appreciate very much that in 2012, we have the 2 training courses delivered by UNCTAD by Christophe here in Vietnam. And thank you very much.
Thank you very much, Vic. I really have very fond memories of the training courses we did in your country. It was fantastic. And yes, by all means, please feel encouraged to translate the summaries that we have in the database into Vietnamese. That is really encouraged from our side. We think this is the best use of the database, and share it with your colleagues, share it with the Training Institute. That would be really, really very good. So by all means, you have our full encouragement for that. Thank you. All right. Would there be any other people that would like to take the floor? I'm not very good at Zoom, so I don't really see if anyone is wanting to, but I think I see no raised hands. So I think we're probably, yeah, we're coming to the end of the launch. Of course, you know that you can always contact us. Ermias showed you how to contact us. You have Viviana's contact details. You have my contact details. Feel free to, contact us for any further comments or questions. But for the time being, I would really like to thank all of you for your active participation and for being present at this launch of the database. Let me very much thank the South Center, our friends, Professor Carlos Correa, Viviana, for your incredibly important support of this work, without which this would not have happened. So really, really thank you to you. And let me also specifically thank my team, Ermias and Clara, for the really hard work that you put into the preparation of the summaries and into the setup of the technical infrastructure. So thanks very much to my team, and all of you have a good and safe and healthy Christmas holiday. Thanks, and all the best to you.
Thank you.
Thank you.
Okay, all the
Thank
best.
you
Bye.
all.
Thank you. Bye-bye.
You get in
Bye-bye. Thank you. Nice to see you.